everybody, and welcome back to the video lecture series part 2 of civil procedure. So once the pretrial scheduling conference is done, a scheduling order is entered. These are issued in every single case. They're often issued after this planning report. So this planning report is officially a 26F discovery planning report. And then there's the proposed scheduling order that usually the parties are requested to draft for the court, and the court would approve and sign it. These orders dictate the following, okay? Times for joinder, times for amending pleadings, times to complete discovery, times for pretrial motions to be done and completed, and time for pretrial conference and any other mediation or settlement proceedings before trial. Sometimes the trial date is given in these orders, sometimes it is not. It depends on your jurisdiction. But once they're set, you usually ask for, I think discovery can be completed in 3 months or 6 months. You give a timeline based on how many experts that you think you have, which is the big one, how many witnesses you think you have. Will there be really contentious issues of law or fact? Do you think that there are going to be contentious summary judgment motions on both sides? This is everything that you're looking into to decide what is the real timing for this case. And you want to present the real time to the judge and not something that's a maybe, because truly they can only be modified if there is good cause shown for the modification and only if the judge consents. These can't be modified just by the attorneys. A lot of attorneys try to call up the other, and I've been guilty of this too, and saying, hey, I don't think that I'm going to be able to finish this discovery in time. Will you give me a couple of extra weeks? It does work if both parties agree and it's done off the record. But really what should be happening based on this rule is it shouldn't be happening at all. And if it does, both parties would need to go to the court with an amended draft, a draft of an amended order, saying because of these following reasons, we're requesting the extra time. And both of us consent to the extra time and are asking the judge kindly to sign off. That's the procedure that's supposed to be done. So if you're working with another counsel and they say, oh, let's just do it off the record, kindly say to them, I understand and I really appreciate you working with me. Let's continue to work together. Would you consent to a motion and proposed order for the judge that I'll write up for us and you can sign, and we'll enter in the actual court filing system and ask the judge to approve. Then you have to base your current timings. You have to stick with them. You can't just change it until you have that order. So you have to do everything you can to still meet that timeline. Timelines and deadlines are really important civil procedure, and they can catch you off guard. So please be aware that if you're doing one of these orders, you've got to give yourself a little bit of extra time as long as the other side will let you do so, and do everything you can to meet these deadlines.